Okay, I'm going to go ahead. I just muted everybody. So it's 9:05, so I'm going to go ahead and get started. Welcome to our 2021 annual employee meeting for Cityscape, Fog City, and Reliant. Thank you guys all for being here. I know this is the second year we're doing it virtual. I'm really hoping this is going to be the last year that we have to do it virtual. If at all possible, we intend and are hopeful in person next year. Want to introduce our executive team. I'm Nick Berg. I'm the president of Cityscape. Also on the call, we have our vice president, Paul Mora, our chief operating officer, Robin Romo, our chief financial officer, Wayne Lee. I don't know if our co-founders are on, but our co-founders are Kevin Wiley and Ed Dale. Our president of Reliant is Mark Owens. Our Cityscape directors are Francis Serrano, Sergey Gorhovsky, and Joanna Lamb. And our Fog City directors are Rebecca Gloyd and Melanie Malik. So 2021. 2021 has been a year. I would say 2021 was a year where we did a lot of the hard things to get through this pandemic and kind of back to normal. Obviously, the vaccines came out this year. Cityscape is one of the first companies that did a vaccine mandate. And I'm really proud to say that we have 100% compliance with our policy, meaning we got almost everybody vaccinated with the exception of some medical exemptions. So I think that's an incredible accomplishment. I think that was important to do, not just for us having a safe work environment, but also to protect the health and safety of our clients. And I think it was the right thing to do for society at large. So, I'm really appreciative that everybody who stepped up did that. I know this year has been tough. I think everybody in our role or at Cityscape and Fog City and Reliant absorbed a lot of misdirected anger and frustration of residents that are still having to, after 2 years, live under COVID restrictions. So, it's tough. And then we had the whole thing where we were opening up and then we had to shut down again with the Delta wave. So it was a year that had some challenges. So where are we now? Right now, I would say, first of all, Cityscape is solid. Cityscape, we've had excellent client retention. We got through this great. Same with Fog City. Reliant is 100% back and growing, so they're killing it. With COVID, case counts are down significantly and continuing to decline. I do think that this is the last wave. I don't want to declare victory because I already did that once and was wrong with the Delta wave. But I think just with the percentage of people that are vaccinated and where this is going, there may be another winter wave, but it's not going to be like what we've already gone through. Masking. There's been a lot of confusion about masking because I know there was an announcement around that there was an easing of masking restrictions. Unfortunately, the easing actually only applies to offices where 100% of people are verified, vaccinated, and there's no kind of in and out guests or visitors. So unfortunately, none of the on-site offices or on-site, none of our client properties qualify as being able to go mask off, and not even our headquarters qualifies. So nothing's changed with masking. Everybody, regardless of vaccination status, needs to continue to mask indoors. I do think that probably in the next month, vaccinated people are going to be permitted to go mask off, but we're not there yet. Something else we're seeing across really not just our industry, but the country, fortunately hasn't hit Cityscape yet, but it is something that I and our exec team are a little bit concerned about. And that is a phenomenon called the Great Resignation. And what it is there's a lot of workers who, especially people who have careers in customer service right now, who are just feeling exhausted and burnt out and, feeling like they took the brunt of the last 2 years and going through all that we went through. So first I want to validate and acknowledge those feelings. I know that everybody's spent. I feel it. I can see it in some of you. I know that you guys got beat up. I mean, that's always been kind of the life in property management. We get beat up and we pick ourselves up. But this was unusual in what we went through, and this was a black swan kind of 1 in 100 years kind of event. So it was particularly tough. So what I want though is I don't want you to, when you guys are feeling those things, I don't want anybody to do anything rash or short term. And especially as we're getting into the holidays, I want everybody to take the time to recharge and refresh and do some self-care. And when you reflect on what we've all kind of collectively gone through, I want you to be really proud of, that we absorbed all that, and we took it and we made a difference for those communities. And again, I want you to know that I appreciate it. Our executive team appreciates it. And our residents, they might not always show it, but they do realize that you guys did heroic work through this pandemic. So again, I just want to thank you guys for everything. Yeah, again, guys, please do some self-care, and let's Cityscape, it's always been a good place to be. It will continue to be a good place to be. And, we want you guys to be, happy and healthy, and the waters ahead look better than the waters behind. Things look good going forward. With that, we have, so first we're going to have Carolyn from Paychecks do the annual harassment training. This is a requirement we have to do. And then once that happens, we're going to dismiss everybody, dismiss the union folks, and then we're going to have John Holman from NFP review the, I guess there are people in the waiting room, sorry. I don't see them in the waiting room. Oh, there they are. Okay. Then we're going to have John from NFP review benefits. So without further ado, I'm going to invite Carolyn to unmute herself. Carolyn, are you able to unmute?
I am.
All right.
All right. I am going to try to share my PowerPoint, and please.
Oh, and you know what? I'm sorry. I'm also gonna disclose this is being recorded.
I saw that.
Yeah. So we're technically supposed to have everybody live, but there are some people who just absolutely can't make it, so we are recording it. So that doesn't. I just want everybody to be aware of that. I still want you to ask questions, but just be aware that whatever you say is going to be recorded and put on YouTube for the people who can't be here.
I also want to make sure, because I am viewing this on a double screen, can you tell me what you are seeing? Because I want to make sure you're seeing the correct thing.
We do. We see your slides.
All right, great. I am used to this through WebEx, but I am not as used to it through Zoom. So I just wanted to double check that. Like Nick said, my name is Carolyn. I am an HR consultant with Paychecks, and I get to do all these fun trainings for our clients. So without further ado, I want to let you know that the information in this seminar should not be considered legal or accounting advice. I promise you there are no numbers or accounting things in here whatsoever, but we put this at the beginning of all of our trainings. Or other professional advice where facts and circumstances warrant. It's provided for informational purposes only. This seminar may be presented virtually. Obviously it is, and may be recorded, which you are, but please note for anyone who is viewing this recording after the fact, this is not considered applicable training for certification if viewed later. All right, and I'm trying to advance my slides. All right. So I just want to show you all the different related federal and California case laws that come into these trainings. There's a bunch of different lawsuits and different case laws and regulations that come into why we are doing this, beyond the fact that obviously we want to create a great work environment for everyone to be able to work in. For California, we have a state requirement that says all employers of 5 or more employees must provide sexual harassment and abusive conduct prevention training to employees once every 2 years, 1 hour for non-managers and 2 hours for managers. So make sure that you are aware what your company's non-harassment policy is, that you have access to it at times, and you can ignore that questions and comments email. It's basically to ask questions about the seminar, but you have me here, so you don't need that. Today, we're going to talk about harassment and protected classes, because that is the protected classes thing is going to be said multiple times throughout this training. Some things will sound very repetitive because we're trying to pack in a lot of information over the course of an hour. We don't expect you to remember everything, which is why we repeat some things over and over again, so it sticks in your head a little bit more. Who is protected by the law? Who could be held liable? Different types of discrimination, because harassment is a form of discrimination, but not all of the discrimination is harassment. Key concepts and legal definitions of sexual harassment, different types of sexual harassment, what abusive conduct is, and what to do if you've witnessed harassment or been harassed, and then what retaliation is. So, what's the big deal? Harassment is a serious matter that can affect not only the victim, but the entire workplace environment. Just like if someone comes into work in a really bad mood, it doesn't just affect that person, it tends to affect everyone around them. And the same thing goes for harassment. It doesn't just affect the person that is the harasser. It doesn't just affect the person that's being harassed. It affects the entire workplace that's around them. So sexual harassment is a form of discrimination that's based on sex and gender, gender identity, gender expression, and sexual orientation. So we're going to go through those a little bit more in detail as well. But unlawful discrimination is treating a member of a protected class less favorably than others because of that person's membership in that group. And here's that first time about talking about the protected classes, because we're going to be reviewing those two things, sexual harassment and the unlawful discrimination part. So when we go through the federally protected classes, the EEOC covers age, disability, genetic information, national origin, pregnancy, race and color, religion, sex, veteran status, and then any other federally protected classes. And we put that because sometimes they're just added throughout the year. Now, California, you can see this is the federal. California has a few more. They do still have the age 40 and over, but then we add in ancestry, there's color, religious creed, including religious dress and grooming practices, disability, including mental and physical, and HIV and AIDS status, marital status, medical condition, genetic characteristics, national origin, race, sex, gender, gender identity, gender expression, sexual orientation, military, veteran status, and then any other protected class, because again, sometimes we end up adding them. And the big thing about why we include this is because there's case laws going on a lot during the year, and federally and statewide, sometimes they have to add them after the fact because it comes up that a lawsuit will go in and come out that someone wasn't actually protected under one of these protected classes. You'd think out of all of these that we'd probably able to get a protected class in there, but it tends to happen after a lawsuit that if someone can prove that, you know, the marital status wasn't the reason behind it, but it was something more in detail than the marital status, they will then update those protected classes accordingly. So we're going to go through the different protected classes. Gender is an individual's sex assigned at birth. Transgender is a person whose gender identity differs from their sex assigned at birth. Gender identity is an individual's internal understanding and identification with gender. Gender expression is the external communication of a person's gender identity through feminine or masculine behaviors, clothing, or other characteristics. So transgender rights in the workplace says that harassment training should provide practical guidance that support a respectful work environment for LGBT employees. And we'll be going through a few questions. If you have your workbooks, they will be in there as well, so we can take notes on how we can support that workplace environment. So who are the different people protected by the law? It's not just employees and the managers. It's basically anyone who's doing business with you. So employees, clients, applicants, unpaid interns or volunteers, and persons providing services pursuant to a contract in the workplace. Same thing, who's liable under the law? In California, every employer or prospective employer, so if you're an applicant, is liable under the law. Every person in the workplace, including managers, supervisors, subordinates, coworkers, can be found liable for sexual harassment. They can be personally liable for the damages caused by unlawful harassment. So it's really important to understand, because also you all or most of you work in environments where you're dealing with people outside of just fellow employees and managers. You have clients that you work with, people in the buildings that you work with, as well as, I mean, a UPS or a mail person could be coming in, and you are protected from harassment against those people, as well as you shouldn't be harassing those people as well. So, true or false? This is our first check our knowledge. I know you're all muted, so I'm hoping that we can, I don't know, either shout it out or pick someone, or if you want to chat it in, because I will bring the chat up. But volunteers and unpaid interns are not protected against sexual harassment.
False.
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 And, you know, I'm going to jump in real quick here. Capri mailed to everybody's home basically a workbook. So if you have it, you should probably pull it out now, because the questions are basically what we're going over, and the workbook does need to be submitted to Capri. Sorry, Karen.
No. Thank you. I appreciate that. Individuals can be held personally liable for sexual harassment.
True.
True. All right. California law identifies 17 specific protected classes for employment discrimination, harassment, and retaliation. I know you all counted while I had it up on the board. You can just take a guess too.
True.
Good job. Yes, it's true. All right. So different types of discrimination. Now, this training is going to focus mostly or majorly on harassment, which is, again, a form of discrimination. But we do want you to have an overall understanding of the non-discrimination principles. So again, these apply to working conditions in general, hiring, training, promotions, work assignments, transfers, compensation, layoffs, discipline, and discharge. It's important that we're providing a work environment where employees do not feel intimidated, unfairly treated, or segregated from others based on the membership in a protected class. Now, I also like to just restate, it's important to provide a work environment where employees do not feel intimidated, unfairly treated, or segregated from others, period. But we are focusing on that non-harassment part, and protected class is a big part of it. So we do want to have that professional work environment, whether or not someone is in a protected class. We want to treat everyone professionally. So the different types of discrimination, we have differential treatment is when an employee makes a differential treatment claim. They are alleging they were treated differently than other employees in similar situations, and that the difference in treatment was based on a protected class. Now, we don't expect everyone to always be treated equally and be given all the same pay, all the same jobs, all of that, but we need to make sure that when there are differences happening, that it's not based on that protected class. Unintentional discrimination. Discrimination can take different forms and doesn't have to be intentional to be illegal. Unintended discrimination is often based on unconscious bias, which includes stereotypes that a person might have about a group of people without them even being aware. So I'm sure you can think about different times in your life, maybe recently, that you've made snap decisions when you see people even just walking down the side of the street, and you might not realize that you're making those decisions in your head, making those judgments as they happen or what they're based on. But we need to make sure that when we're making decisions in the workplace and treating people, that we're not letting those unconscious biases affect our judgments. And it's hard to really, because it's your unconscious, but this is why we have these trainings, to really uncover those and make sure that we make ourselves more hyper aware, to make sure we have that professional workplace environment. Harassment. If someone is abusing, insulting, or otherwise harming you on a regular basis, it might be considered harassment and can be annoying, sometimes cruel, and even illegal in some cases. So we are going to go into this bit, and I actually miss it. We used to have it as our training where we would do this little red light, green light. And I don't know if anyone remembers, I used to come into Cityscape and do those trainings, and I would have everyone hold up a red light or yellow light card. Anyone? No. But we don't do that as part of the training anymore because California has become more strict with what we need to cover and doing the quizzes throughout the training. But there are different levels of harassment, of whether it is just harassing and annoying, which is still not good, but whether it rises to that illegal part, which is that red light. So we have the yellow light harassment, which may or may not be based on protected classes and therefore not illegal, still don't want it in the workplace environment. But then there's the red that's definitely illegal and should not be in the workplace. So a scenario: Tom is a model employee who's relied upon by his manager, Sue, to mentor and train new employees. The last 3 times a promotion has come up, Tom applied, but the promotion was given to one of the female employees Tom had trained. Is Tom being discriminated against? Oops, I can't go back. Anyone? Maybe, yes, it's possible. We don't have enough information to really know whether that is why Tom is not being given those promotions. So is it because he's a man, or does it have something else to do with his work and how he does at his job? All right, so true or false? The California FEHA prohibits discrimination and harassment based on several protected characteristics in addition to the federal ones.
True.
True. And what does FEHA stand for? And feel free to reference the question above that says the California FEHA prohibits.
Fair Employment and Housing Act.
Good job. Which of the following is a potential negative impact of workplace harassment? D, all of these. Some people are chatting in. I'm assuming you can see that. True or false? Both employees and applicants are protected under anti-discrimination laws enforced by EEOC. Where's my chat group at? Anyone? True. Yay. All right. Which term best describes a situation where an employee is a victim of discrimination, including harassment, and the conditions are so bad they're compelled to resign? Now, we haven't covered this yet, so let's just kind of try to take an educated guess. Or uneducated guess. Just a guess.
Hostile environment.
That's not one of the options. Can you see the screen?
B.
B, constructive discharge. All right. So unlawful harassment, because we talked about how harassment doesn't always fall into the unlawful part, is unwelcome conduct based on a protected class where enduring the offensive conduct becomes a condition of continued employment, or it's so severe and pervasive it creates a work environment that a reasonable person would consider intimidating, hostile, or abusive. It's important to note that standards for conduct and behavior that could be considered harassment may be adjusted in the future based on claims received and cases heard in the courts. This is also why protected classes are always changing. While illegal harassment is a form of discrimination, not all discrimination claims are necessarily considered harassment. And since no one said that they remembered me giving training, I'm going to make my joke that I make in all of my non-harassment ones. It's like your hands where your thumb is a finger, but not all of your fingers are thumbs. That would be really weird and awkward. So discrimination, harassment is always a form of discrimination, but discrimination is not always harassment. So think back to the example of Tom. Tom is a model employee who is relied upon by his manager, Sue, to mentor and train new employees. The last 3 times the promotion opportunity came up, Tom applied, but it was given to one of the female employees Tom had trained. Could this scenario also be considered harassment?
True.
So it could maybe be not just discrimination, but harassment based on protected classes, but we also don't know further details and would want to look into that more. So sexual harassment is unwelcome sexual advances, requests for sexual favors, other verbal or physical conduct of a sexual nature when it explicitly or implicitly affects someone's employment, it unreasonably interferes with work performance, or it creates an intimidating, hostile, or offensive work environment. The California arm, FIHA, defines sexual harassment as harassment based on sex or of a sexual nature, gender identity, gender expression, sexual orientation, gender harassment, harassment based on pregnancy, childbirth, or a related medical condition. So the definition of sexual harassment includes many forms of offensive behavior, including same-sex harassment. And FIHA spells that out because there have been claims outside of California that have been lost because someone was able to prove that they had no sexual desires to someone. So technically it wasn't sexual harassment, which would not fly in California. So sexual harassment can occur between individuals of the same sex. Like I just said, sexual desire is not required, and adverse employment action is not always required, because if it's just a bad environment for someone to be working in and they have to go through this, it's a hostile work environment, that is still considered sexual harassment. So sexual desire is a key element of any sexual harassment claim. True or false?
False.
Any employee
False.
can claim sexual harassment even if the supervisor took no adverse employment action.
True.
True. Yay. All right. So sexual harassment. There are two different types of sexual harassment. We've got quid pro quo and hostile work environment. So we're going to go through another scenario. Michael asks his administrative assistant, Christian, to stay late to work on a project. When they're alone, Michael makes sexual advances towards Christian. Christian tells him he has a boyfriend, is not interested. Michael continues to pressure Christian, telling him that he can kiss his career goodbye if he won't comply with requests. Just remember that for the future. When sexual harassment favors are demanded in return for tangible employment benefits, the threat can be expressed or implied. This is quid pro quo. So this for that. Typically quid pro quo is something that is from a higher level to another level of employee. Basically someone who can control the outcome of someone's work environment and career. So typically there is tangible employment benefits tied to this. Now, sometimes it can be employee to employee, especially if one of the employees who are making those demands is able to influence managers or influence the person's career. But typically it is from management to the employee level. So remember Tom from our previous scenario. What if Tom had an email from his manager stating that he would only get promoted if he went out on a date with her? So this is not the one we just talked about with Christian. This is the one all the way back when we were asking, could this be harassment? Would this now be harassment?
Yeah.
Yes. All right. So checking our knowledge, Blake, the sole proprietor of Acme Co, has decided to expand and compete for state contracts. Blake hires Jack, an independent contractor, to install a network. Blake threatens to sue Jack for breach of contract unless Jack agrees to engage in sexual activity. Which of the following statements is true? Jack can't sue Blake because he's an independent contractor. Jack can't sue Blake because Acme has fewer than 5 employees. Jack can't sue Blake because he's a man, or Jack can sue Blake for quid pro quo, sexual harassment. D, yes, he can sue. All right, so who is typically the perpetrator for quid pro quo harassment? What? You didn't see that. Person with authority or influence, yes. True or false? Quid pro quo sexual harassment can be based on one single event.
True.
True. All right. Now moving into hostile work environments. A sexually hostile work environment can be described as intimidating, hostile, or offensive, where a protected individual is subject to unwelcome gender-based sexual conduct that is pervasive or severe enough to alter the terms of conditions of the person's employment. So hostile work environment harassment is conduct which sufficiently severe or pervasive and alters the conditions of employment to the extent that it creates a hostile or abusive work environment. A reasonable person, which we've said that a few times before, and we want to recognize what a reasonable person standard is. It's someone that has an ordinary degree of reason, prudence, care, foresight, intelligence, whose conduct, conclusion, or expectation in relation to a particular circumstance or fact is used as an objective standard by which to measure or determine something. So this is basically, would a reasonable person find this an uncomfortable environment that they're going through? Other things to consider: the nature, the frequency, the period of time over which this occurs, whether it's physically threatening or humiliating, and the extent to which the conduct unreasonably interferes with the work performance. So does a hostile work environment have to be caused by a manager?
No.
I see shaking of heads. No, correct. So Megan is a customer service representative at wholesale distributor. Jim, an employee of one of her company's biggest customers, comes to the distribution center weekly to pick up orders. When he does, he always waits for Megan to be available. For some time, Megan hasn't thought anything of it. They might joke or flirt a little, but that's all. Recently, Jim asked Megan out on a date. She said no, telling him that she's in a committed relationship, but Jim isn't taking no for an answer. Every week he asks if she is ready to go out. Megan's tired of having to tell Jim no, and although she has mentioned her concern to her supervisor, she doesn't want to keep complaining since Jim's company is a very important customer. Can this be considered unlawful sexual harassment?
Yes.
Yes. All right, so courts have recognized 3 different types of hostile work environments: conduct directed at a claimant, conduct directed at others, and widespread sexual favoritism. Harassing conduct includes unwanted sexual advances that can be verbal, visual, or physical. So verbal is basically, could be foul language, derogatory comments, explicit discussions about sexual activities, or comments about other people's physical attributes. So this I've seen in work environments a lot of times, and people get very uncomfortable saying that they're uncomfortable with these conversations because they don't want to be, I think the term is wet blankets. They don't want to bring anyone's mood down, but it's really important that we know that these work environment is not a place for that type of discussion. And I think you can all imagine in your head what type of explicit discussions we're talking about, or comments about other people's physical attributes. Visual harassing conduct can include leering, staring, making sexual gestures, displaying sexually explicit objects, pictures, cartoons, graffiti, or posters, sending graphic emails, text messages, or jokes. This is one that I've seen go very badly very quickly as well, where people send out an email, it gets forwarded to more people than it was intended, and you are in a large organization as well. You can see how not everyone is going to find all of the jokes appropriate or funny. I've worked in an environment where a manager used to walk around to other people's computers that were unlocked and send out funny messages to prove a point that you should lock your computers when you walk away. Most of the time it was harmless, but one time he sent out an invite to a pool party and at this manager's house for the weekend, but he also attached images of Playboy bunnies in scantily clad outfits. So in an environment of 800 employees, there were a few people that found that highly inappropriate to be sending out. So just make sure that when you're sending out things that they are appropriate for the workplace environment. Physical harassing conduct can include kissing, hugging, grabbing, impeding or blocking movement or assaults. Now, I know workplaces have changed. If you're still working near people, probably aren't doing the hugging to greet each other as much as we once may have in the workplace environment, but I do still like to bring this up. And it's important even more so now to appreciate that some people are more uncomfortable with physical touch than others. I'm in HR. HR is a very huggy type of position. Anytime I used to go to meetings, my peers would hug and say hello. They have since learned that I am not a person that likes physical touch, especially in the workplace environment. Now, me telling them, hey, I prefer handshakes, and then them forgetting because we don't see each other for 3 months and they try to hug me again, I'm not going to consider that harassment. But in one of my previous workplace environments, I made it very clear to people who tried to hug me that I liked handshakes, and someone went out of their way to try to hug me every day to quote unquote break me of that uncomfortability. Now that is getting to that harassment part because they're doing it to make me feel uncomfortable, and they're doing it in a repetitive fashion, and that is going to rise to the level of harassment. Obviously, I was still okay with addressing that and making that stop, but not everyone's going to be. So beware of what people's comfort levels are and respect that. Don't make them feel bad for not wanting to be physical. So you and Chris have been good friends for years. You've dated on several occasions. Last week, Chris was promoted to director. He's not your direct supervisor, but is head of your division. Chris stops by your office and asks you to dinner, concerned about how having dinner will look. You decline. Chris leans over your desk and states if you want to be promoted, it's in your best interest to go to dinner. Is this quid pro quo or hostile work environment? Got a quick answer, quid pro quo. QPQ, I like that. Your work area is in the back office operation that's pretty hectic. Men and women both refer to each other using derogatory terms. One of your coworkers visits a website every morning and shouts out the joke of the day, which is always of a sexual nature. Most of the workers participate, but some feel uncomfortable. Is this hostile work environment or quid pro quo? Hostile work environment, yes. True or false? To prove hostile work environment, sexual harassment, the complaining party does not need to show that they suffered an adverse employment action. It's a very weirdly worded question. True, I'm just going to give that to you. To prove hostile work environment, sexual harassment, the complaining party must show that they were subjected to unwanted sexual attention that was severe and pervasive.
False.
False, correct. All right, so we went through it in the other slides when we were talking about verbal, physical types of sexual harassment, but these are just examples. So sexually offensive jokes, pictures, or sexual comments, rude treatment of women or men because of their gender, unwanted invitations, notes, and flirtation, gossip, rumors, other discussions about employee sexual orientation or gender identity, sex as implied condition for promotion, harassment after a breakup of a relationship for employees, between employees. Examples of nonverbal sexual harassment can include emails with sexually suggestive messages, pornographic pictures, etc. Physical harassment, including touching, massaging, invasion of personal space, and physical assault, or leering or elevator eyes, which I find that term funny because I don't know that anyone calls it that anymore, but there it is. True or false? A male employee can be the victim of sexual harassment.
True.
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 Unlawful harassment can occur where both individuals are of the same sex.
True.
True. All right, another example. Pete and Angela work together in the finance department. They both enjoy listening to the same genre of music. Pete asks Angela if she'd like to go to a concert. Angela thanks Pete, but tells him she's not interested in going out with him. This is not an example of sexual harassment. Now, if Pete continued to ask and badger her, then it would start to go into that. So we're not saying you can't be friends or friendly. You just want to make sure you are appreciating people's boundaries. Does sexual desire have to be the underlying reason for sexual harassment?
No.
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 Correct. Is asking a coworker out on a date considered sexual harassment?
No.
No.
No. Correct. All right. So malicious conduct of an employer or employee in the workplace that a reasonable person would find hostile, offensive, and unrelated to an employer's legitimate business interests. This sounds very familiar and very close to what harassment is, but this falls into what we call abusive conduct. And California likes us to give a training at the end of the harassment trainings to cover abusive conduct because they want you to know the difference. They also want you to know that both are not something that should be in the workplace environment, but it's really important to know what the difference is between the two of them. So abusive conduct can be verbal or physical, just like harassment. It may include repeated infliction of verbal abuse, such as the use of derogatory remarks, insults, threats, intimidation, humiliation, and the gratuitous sabotage or undermining of a person's work performance. Now, who can tell me what's missing from this that doesn't make it harassment? Anyone remember that term that I said was going to be thrown out here a few times?
Protected class?
Yes, protected classes. So how is abusive conduct different from harassment? Harassment is the form of discrimination and defined as unwelcome conduct based on, there you go, that protected class. Abusive conduct is hostile, offensive, malicious behaviors intended to humiliate, threaten, or intimidate someone. The biggest difference is that unlawful harassment is based on that protective class. Abusive conduct may not be. That person might just be a jerk to everyone, regardless of the protected class. So, what is the Latin phrase when used when a person of authority demands sexual favors in return for promotion or other? Hey, quid pro quo. True or false? Under California law, an employee, applicant, unpaid intern, volunteer, or persons providing services can create a hostile work environment. True. All right. How does the Fair Employment Housing Council define gender identity? A. Yes. Sorry, I saw that in chat. Wasn't sure if it was for one of the old questions. If you've been harassed, you want to immediately tell the alleged harasser that behavior is unacceptable and unwelcome. If you're unable to confront the alleged harasser, or if the unwelcome behavior continues, immediately report the incident to a person indicated in your company's no harassment policy. So, like my example of that person that really wanted to hug me every day, I, of course, told him to stop on a regular basis. And when it got to the point that he wasn't, I did address it with his manager. I was HR, so I was the person in the no harassment policy, but I obviously needed to get a little bit more someone behind me to get him to stop, because my repeated attempts to ask him to stop wasn't working. So, and if you're uncomfortable making that first step, it's still okay to just go directly to a supervisor and ask them to help to get it to stop. It's also important that even if the person does stop, that you report it, because it's possible that this person is doing it to other people. So the likelihood that someone doing that uncomfortable behavior to just one person is pretty low, because a lot of the harassment, I'm not saying all, but a lot of the harassment that I see in workplace environments are ones that kind of fall into that unintentional harassment. He really didn't think that he was being harassing. He didn't think it should make me uncomfortable, because he thought hugs were a great thing in the workplace environment. And he just wasn't recognizing that everyone has their own personal boundaries, and just because they don't match with that his boundary doesn't make it invalid. So a lot of times, if they stop harassing you, they might still be making someone else uncomfortable. So if you witness harassment or become aware of potential instances of sexual harassment, you should report it to a supervisor, manager, or person designated in your no harassment policy. Does anyone know who is designated in your no harassment policy?
Capri?
That is
Pretty
correct. So yeah,
What?
this is Nick. So Capri is a designated person, and then anybody on our executive team. So me, Robin, Paul, Wayne, Mark Owens, Francis, Sergey, Joanna, Rebecca, Melanie. You can come to any of the exec team.
Awesome. I was pretty sure it was that, but I wanted to make sure it hadn't changed. All right. So bystander intervention. A bystander is someone who witnesses sexual harassment. A victim is someone who's been sexually harassed, and an ally is a person who believes sexual harassment is wrong, supports the victim, and takes action to stop sexual harassment. Everyone has the right to work in a harassment-free workplace, and that takes more than just that one person. It takes everyone in the workplace to help with that. Going back to if someone feels uncomfortable, if someone is being harassed and they don't say anything, or even if the message makes you uncomfortable, I've seen that in a few situations, it's really important to step up and show that person who's being harassed that you have their back so they feel comfortable in speaking up. So you can confront the harasser, say stop, be an ally to the victim, show your support, document what you see, support the victim if they need it, interrupt or distract the harasser, and follow up with the victim. So make sure after everything has dissipated that you're checking in with them and seeing how they are, see if they reported anything, make sure you're reporting it, make sure they're not still being harassed just when you're not around. So best practices for employees to help prevent harassment: avoid engaging in behavior that might be considered harassment. Now, if we all did that, this would be awesome, because then we wouldn't have these issues. But avoid engaging in behavior that can be any way demeaning, embarrassing, or offensive to others. I completely understand that sometimes we make jokes, but it is likely not the best place to do it in the workplace environment. You might find it funny, someone might laugh it off, but they might not actually be finding that funny. Correct harassment situations by acting in a prompt, fair, and confidential manner. Be aware of your behavior toward any employee who may have complained of harassment. So if they've said that they're uncomfortable with nicknames in the past, don't give them a new nickname, call them by their name. Or if they've said they're bothered by the fact that people mispronounce their name or shorten it just to make it easier for them, again, respect them, try to work with them to get their name correctly. The fact that someone files a complaint of harassment doesn't mean that they're disloyal to the team. It means that they need and deserve to work in a positive workplace environment. Gone are the days when we say, oh, they're just being too sensitive. We need to respect people's boundaries and respect what makes them feel comfortable. Your company is committed to protecting the confidentiality of employees who report harassment to the extent that it's possible and consistent with their investigation. So remedies for people that are feeling harassed: employees, applicants, unpaid interns or volunteers, or people providing services pursuant to a contract in the workplace who feel they've been subject to harassment in the workplace may take any of the following steps. Ideally, we're following the company's internal procedures and report the act immediately to one of the people indicated on your no harassment policy. And ideally, we're going through all of those things to make sure that that harassment stops. If you're feeling uncomfortable and not able to go to someone in the no harassment policy, you can contact the EEOC or the California Department of Fair Employment and Housing. Things that can happen for remedies under to protect individuals from discrimination, including harassment, could be injunctive relief, so training, development, or changes in policies, economic damages, reimbursement for lost wages and benefits, non-economic damages, so reimbursement for emotional distress or loss of enjoyment of life, hiring or reinstatement, reasonable accommodations, recovery of attorney's fees or other fees, compensatory damages, so out-of-pocket expenses for any emotional harm suffered, punitive damages, or liquidated damages equal to the amount of back pay awarded. In California, complaints must be filed with the EEOC within 180 calendar days from the date of discrimination. It can be extended to 300 if a state or local agency enforces a law that prohibits employment discrimination on the same basis. And with the California DFEH, within 3 years of the date of alleged violation. Different resources available: the Employee Assistance Program services, which are available through paychecks for Cityscape employees, include access to qualified counselors, crisis intervention, management consultation and support, employee handbook policies. So if you're not familiar with the different policies that help support this, I would review EEO statement, the no harassment policy, your employee relations philosophies, and management and employee training, which is what we're doing right now. Yay! All right, retaliation. It's illegal to retaliate against people, applicants, or employees because they filed a charge of discrimination or because they complained to their employer or other covered entity about discrimination, or because they participated in an employment discrimination proceeding, investigation, or lawsuit. So if you're a witness to harassment and you are speaking up and being a witness, you also cannot be retaliated against. Different forms of retaliation may include dismissal or demotion, transfer or change in responsibilities without justification. So ideally, if you're transferring or changing responsibilities to address harassment that is hard to control otherwise, an example that I give, because I've seen, I have a few law firms that are clients that have dealt with harassment, not internally, but from judges. And as much as they can report the judges, it doesn't always fix the harassment. So sometimes transferring cases or making sure that a person doesn't have to deal with that judge is a way that they can address the harassment. Obviously, that is with justification. That's why I like to draw that line. Negative evaluations or decrease in pay rate. If an employee feels they're being retaliated against, they should report it to the person in their no harassment policy. All right, which of the following might be awarded as a remedy to a victim of employment discrimination? D, all of these. How long from the date of alleged violation of the California Fair Employment and Housing Act may an employee file a complaint with the California Department of Fair Employment and Housing? Oh, I thought I saw a D. It's D, 3 years. The 180 was for the EEOC. True or false? If you observe harassment taking place in the workplace, it's best to let the people involved resolve it between themselves.
False.
False. If you honestly do not intend to offend anyone, your behavior cannot be considered harassment.
False.
False. If someone lets you know that your behavior makes them uncomfortable, you should stop that behavior immediately and not engage in that behavior again.
True.
True. Good job. All right. If an employee witnesses a potential harassment situation, should they approach the harasser? Should they try to console the employee being harassed? They should report the situation or mind their own business and do nothing. Yes.
C.
During this training, we have reviewed harassment and protected classes, who's protected by the law, who can be held liable, different types of discrimination, key concepts and legal definitions of sexual harassment, types of sexual harassment, abusive conduct, what to do if you've witnessed or been harassed, and the investigation process and retaliation. Does anyone have any questions or comments?
I'll make a comment. So, yeah, guys, we Cityscape, Reliant and Fox City, we take this really seriously. We want to have a harassment-free workplace. It takes everybody's participation to make that happen. So, if something's happening, we really want to know about it, because if something's going on, we want to address it. And yeah, so if you let us know, we will take action. Go ahead.
And can I add to that as well?
Sure.
Non-harassment training is required by California, but Cityscape has been doing these non-harassment trainings before that requirement was even required in California. I know, because I was the one presenting it for you guys. So I just want to echo Nick's statement that yes, this is a very important thing to Cityscape.
Yeah. Cityscape doesn't have an anti-fraternization, which is kind of like there are companies that say no dating in the workplace is allowed. We don't have that. We want to treat you guys like adults. Having said that, if you want my kind of unofficial advice, dating coworkers and clients, I don't recommend it. But if you are dating somebody in the workplace or in a romantic relationship with a coworker, and there's a reporting relationship, we want to know about it. Let us, make Capri aware of it. Nobody's going to get fired. We just want to make sure that we may have to change the reporting relationship so that we're avoiding any potential issues there.
All right, well, that is all I have for you. Thanks for having me today, and I hope you have a good rest of your meeting.
thank you.
Thank you, so
All
much,
right.
Carolyn.
Yep. Bye.
Thank you.
All right. How's everybody doing? So that's the harassment training. Next on the agenda is going to be NFP to talk about the benefits. We're going to go ahead and dismiss the union employees so they don't have to stick around for this portion. So I want to, the union employees, thank you guys for joining us. But you guys are dismissed.
Thanks, guys.
And I'm going to stop recording.